It's so hard to collect as a Florida subcontractor. Here you go. Stop crying and listen up. It's incredibly easy to collect compared to other industries. You don't know how good you have it. Florida's construction lien law favors you big time. You just have to learn how to use it, and that's going to take a little bit of effort. The alternative is you can keep crying. This video is going to show you how a subcontractor can have the court auction off the owner's property. It doesn't matter that it's his homestead exempt property, and it doesn't matter that you don't have a contract directly with the owner. A construction lien can be foreclosed on the same way a bank forecloses on an unpaid mortgage. You do not need the owner to want to sell. You sue him. If he loses the lawsuit, that property gets sold, whether he likes it or not. That's the purpose of Florida's construction lien law. A lot of people think you place the lien and then hope that they want to sell or refinance and you'll get paid. Those are unintended side effects. That's not the purpose of the law. When that property gets sold, not only does the clerk pay you for your work out of the proceeds, they also pay for your attorney's fees, court costs, and interest. Why should you care about going after the property owner instead of the general contractor? Take a good look at the general contractor. Go to Sunbiz, look up his address. Is that business run out of a house? Good luck getting paid. The owner's property serves to guarantee payment for your work. They made Florida's construction lien law just for you, just to protect those who provide construction labor and materials. All you have to do is comply with the construction lien law. After watching this video, you're not going to be prepared to handle a construction lien case from start to finish. This video is intended just to show you what is possible. It's not meant to cover every aspect of construction lien law. And there's a lot of little wrinkles in the law that can work for you or against you. And you should proceed with an attorney. There's 3 deadlines that you should be aware of. The first is the notice to owner. The second is the filing of the lien. And the third is the filing of the lawsuit. The law is unforgiving when it comes to these 3 deadlines. There are a lot of other things that the court doesn't require strict compliance. These 3, if you're 1 day late, you lost your lien rights. A notice to owner is not something that you send because you didn't get paid. It just lets the owner know that you're working on his property. That's it. That way, he has the opportunity to make sure that you get paid by requiring the GC to give him a release from you before he makes payment. Otherwise, it wouldn't be fair for you to put a lien on his property and foreclose on it. In other words, the receipt of a notice to owner makes the owner responsible for making sure that you get paid. The moment he receives it, he becomes your collections manager on that project, and he works for you for free. His shift starts the moment he receives the notice to owner, and it ends, 1, when you get paid and give him a release, 2, when you mess up your lien rights. That notice to owner has to be received by the owner within 45 days of you starting the job. And it also has to be received before the general contractor gives the owner a final payment affidavit and the owner makes payment. That second part may happen sooner than 45 days. That's why you want to send your notice to owner as early as possible. Here's a pro tip. Your real deadline is day 40, not day 45. Why? Because if you deposit it in the mail on day 40 or earlier, you don't have to worry about when the owner receives it. It's considered received the day you put it in the mail, so long as you sent it by one of the acceptable means in the statute. You can't go wrong with certified mail with electronic return receipt. Here's another pro tip for the last guys on the job. You want to send it as early as possible because it also has to be received by the owner prior to getting that final payment affidavit from the GC and prior to him making the final payment. If you had a contract directly with the owner, in other words, you're not a subcontractor, you will look foolish if you send a notice to owner. It's not necessary. All it does is tell the owner, wow, this guy is clueless. Now let's talk about the claim of lien. The claim of lien has to be recorded with the clerk of courts for the county in which the property is located. It has to be recorded within 90 days of you finishing the job. The term in the statute is final furnishing. Final furnishing is not measured by inspections. It's not measured by punch list work. A good shortcut is it's the last day that you did work in furtherance of completing the the job, not including corrective work. Here's why you don't want to wait until day 90 or anywhere near it. If this goes to a lawsuit, you are opening up defenses for the owner. They will argue that you weren't actually on the job that day. They will argue that you had finished a couple of days earlier. They will also argue that the work you did was corrective and therefore does not count for the 90 days. The earlier you file, the harder it is for them to prove those defenses. By this point, you sent your notice to owner and you filed your claim of lien. You'll get paid the majority of the time just from those two steps. However, if you don't, you'll have 1 year to bring a foreclosure suit. There is no extending a construction lien. There is no renewing a construction lien. It lasts 1 year and you use it or you lose it. The owner can actually shorten that 1 year period by filing and mailing a notice of contest of lien or by bringing suit for an order to show cause. In this lawsuit, the prevailing party will get their attorney's fees paid by the other side. The construction lien law has it written into there. However, there's a way to make that one-sided. You send a demand for sworn statement under Florida Statute 713.16. And if they don't respond in 30 days, they cannot be the prevailing party, even if they win the lawsuit. This is one of the ways we protect our clients. Because before we file suit, we'll know what their exposure to attorney's fees is. If they ignore that demand letter, your worst case scenario is the very spot that you're in right now, unpaid. In your lawsuit, you can also join the GC for breach of contract. Now, you have to be careful doing that because they may have an attorney's fee provision that isn't subject to that sworn statement demand, and they may have an arbitration clause. But if you have a construction lien, you can choose to leave them out and just go after the owner. And you don't have to worry about the attorney's fee provision in the contract or the arbitration clause. Now, if you win the lawsuit, which pretty much means your lien didn't have any defects, you did the work, the craftsmanship was acceptable, and you haven't been paid, the court will sell the property and they'll pay you. And then they'll pay any junior lien owners. Superior liens, like the mortgage most of the time, does not get paid. However, those liens run with the property. That's why you have to worry about the equity in the property that you're trying to foreclose on. Now, all the wannabe internet lawyers, they love to say construction liens don't work because they'll just bond them off. First of all, you guys probably don't even know what a bond is or how it works. When a lien gets bonded off, it's the best thing that could happen to you because roughly 150% of your lien gets deposited as cold hard cash. Now you don't have to worry about equity. If there's any topics that you want us to cover, just comment down below